Dr. Albert, you may say so, the judge may claim so, but the judge committed what majority of the people describe as a travesty of justice, and I tell you why.
No, he's not
a mob opinion because there are the facts are there. The judge jumped into the arena. The judge even usurped the office of the executive.
How?
I'll tell you why. It does not lie in the purview of the court to decide where a convict will be kept. The very moment you decide, you give it your judgment, you become functus officio. It is the duty of the executive to determine.
Which means that the matter has ended.
Yeah, the matter has ended. It's the duty of the for the judge to say. For the judge to say he has to be kept in a certain form of confinement. He's jumping into the arena. He's overreaching his office.
Was it the judge that said he must be taken to Sokoto?
The judge said so, and possibly for them to have taken him to Sokoto, they may be obeying again the order of the court, which of course is an illegal order because he has become functus officio.
No,
it is not the duty.
Sokoto prison.
It is not the duty
in that judgment.
It is not the duty of.
No, is it stated in the judgment?
No, Dr. Albert, it's not the duty of the judge to say where he will be kept.
No, is it in the judgment?
No, it's not in the judgment.
Have you read it?
No, but he said so in the judgment that
he said it should be taken to Sokoto.
He didn't say Sokoto. He said in a special confinement.
A very good news to Mazi Nnamdikanu. What you're about to hear is more than just another commentary. It is a constitutional lawyer breaking down exactly what happened on the day Justice James Omotosho delivered his ruling on Nnamdi Kanu. And his analysis raises serious question. Was this judgment grounded in law or in personal opinion or emotion? From the lawyer's perspectives, the entire processes didn't just look predicated on anger. It seemed preempted in anger as well. His breakdown exposes why Nnamdi Kanu repeatedly insisted on repeal law, and reveals deeper issues that suggest the conviction may have been legally shaky from the start. But in this interview, Ruben Abati acted so anti-Igbo. He obviously tried everything possible to stop this man from saying what he wanted to say. And as you see, the conversation itself wasn't smooth. Ruben Abati appeared determined to cut in and steer the discussion away, even as the constitutional expert tried to explain the legal realities point by point. But despite the interruption, the lawyer's explanation is powerful, detailed, and honestly revealing. After watching his analysis, many things became clearer. The mood in court, the questionable legal foundation of the judgment, and why so many people felt something was off from the very beginning.
The attitude of the court itself, whether the court followed the law or whether the court followed personal opinion of the jurists, or whether the court, in some people's opinion, acted on a script to ensure that Nnamdi Kanu is taken off the streets in a manner of speaking. Whether Nnamdi Kanu defended himself or not, what to many people is more critical and more important is the attitude of the judge and the justice of the matter. Don't forget that in criminal adjudication, one can only be convicted when there is preponderance of evidence, one, two, and when the prosecution is able to prove the case beyond all reasonable doubt. We are not saying all iota of doubt, but at least all reasonable doubt. And that justice must not only be done, but to be seen, manifestly be seen as having been done. The generality of the public of Nigeria and even the international community do not believe that justice was done in Nnamdi Kanu's case. Don't forget that the issue of treason is a political decision by the state, because treason is an offense against the state. It has been brought to become an offense against humanity. And that is why there is an international convention against treason. And it was to be able to bring it to the level of, to align Nigeria's act with that of the rest of the world, following the UN convention, that brought to the repeal of Nigeria's 2011-2012 terrorism Prevention Act, and reenacted in 2022 with implementation in 2023 of Terrorism Prevention and Prohibition Act. Now, the whole issue about Nnamdi Kanu's matter beggars a lot of questions and defeats a lot of logic, because a lot of people, even Nnamdi Kanu himself, had continued to say it, even rambunctiously in court, that they should show him the law with which he's being tried. Because by the time many people didn't understand, because all the people who were not privy to the charges and people who were not privy to the goings on in court were at a loss as to why would a man be charged for an offense that is not known to law in a criminal trial. Because a Nigerian statute book says that one cannot be tried for a law of an offense not codified and known to law. And then
under the principle of fair
hearing.
Sections 35 and 36.
Absolutely. And there is nothing like retrogressive action in law when it comes to criminal action. Yeah. We are not a military regime. Now...
No, but Nnamdikanu was charged under the old law.
Under the old law.
Terrorism.
He was charged under the 2020...
No, not under 2022. Under the older law of 2011.
2013, yeah. Not 2022, 2013. That was repealed.
That's the old law.
Oh, the old law that was repealed in 2022.
Yeah, but so, the new law will not take effect. That's why Chief Awomolo SAN is saying that the punishment is death penalty. He was quoting the old law, and that the accused person was charged under the old law.
The accused person was charged under the old law. Don't forget that charge under the old law got extinguished in October 2022. But
the law, you yourself just said it, cannot have retroactive effect.
We cannot have retroactive effect.
Those are issues they will resolve at the level of appeal.
No. There is one major issue that is even on the open. Okay. Because in the first instance, don't forget that Nnamdi Kanu had earlier been acquitted by the Federal High Court before the federal government went to Court of Appeal. And every moment an accused is acquitted, discharged and acquitted, he goes home from the court. He can only go back to the prison or to wherever he was detained to collect his personal items. If he doesn't want, he can abandon them there. If he doesn't want, he can go from there to his house. If he doesn't want, because at the end of the day, the federal government refused to release him. So at that point of that discharge and acquittal in October of 2022, the court became functus officio. So you can no longer hold on that old law. But by the time you saw the judgment from the Omotosho's court, it was referring to the 2013 charge. So that became a very, very strong issue against that judgment and against the entire procedure. Okay. There are so many other issues which time may not allow us to explain.
These are issues that can be worked out when the matter goes to the Court of Appeal. Aloy Ejimako has already said they will go on appeal. Yes, and that by Monday, tomorrow, they are going to file.
He has a whole 90 days. We think we to do so.
However,
he
can
do that
to
at any
notice
time.
that Justice Omotosho even said, he was tampering justice with mercy. He was not applying the full teeth of the law. However, what do you think is the way forward? And don't you think that the matter was even complicated by the conduct of the accused person who discharged his own counsel? I mentioned the very senior lawyers who know the territory. Now, in this same case, what's his name now? Ozekome, SAN, was involved. Kanu Agabi, SAN. Paul Erokoro, SAN, Ikpeazu, SAN. These are people who know the law, the in and out of it, who could have provided a different kind of pathway and who could have handled the matter. But we had the accused person abusing the presiding judge, and you said, the presiding judge is the problem. What do you expect his lordship to have done in a situation whereby the accused person took over the proceedings of the court and questioned his integrity, questioned his... So what the judge did eventually in the 144-page judgment that I have seen is that he just applied the law. Simply.
Dr. Abati, you may say so, the judge may claim so, but the judge committed what majority of the people describe as a travesty of justice, and I tell you why.
No, look, don't quote mob opinion.
It's not a mob opinion because there are the facts are there. The judge jumped into the arena. The judge even usurped the office of the executive.
How?
I'll tell you why. It does not lie in the purview of the court to decide where a convict will be kept. The very moment you decide, you give your judgment, you become functus officio. It is the duty of the executive to determine.
Which means that the matter has ended.
Yeah, the matter has ended. It's the duty of the for the judge to say.
That's what functus officio
means. For the judge to say he has to be kept in a certain form of confinement. He's jumping into the arena. He's overreaching his office.
Was it the judge that said he must be taken to Sokoto?
The judge said so, and possibly for them to have taken him to Sokoto, they may be obeying again the order of the court, which of course is an illegal order because he has become functus officio.
No, it is not the duty. Sokoto prison.
It is not the duty
in that judgment.
It is not the duty of.
No, is it stated in the judgment?
No, Dr. Abati, it's not the duty of the judge to say where he will be kept.
No, is it in the judgment?
No, it's not in the judgment.
Have you read it?
No, but he said so in the judgment that
he said it should be taken to Sokoto.
He didn't say Sokoto. He said in a special confinement. He said so. People were asking, would he be taken to Robben Island in South Africa or Guantanamo Bay in Rhodes Island in America, since they wanted him to be completely out of circulation? The judge, in his wisdom, may be thinking that keeping him in an environment where people can have access to him, that people will be coming to visit him, and of course people will be going to visit him. And now the government are now throwing him to Sokoto. What is the basis for him to Sokoto. That is one. But leave that for the executive to answer. But you can query the judge for making such statement because it does not lie in his purview. Again, the injustice done against Nnamdi
was that part of the ratio or part of?
It was part of the angst you mentioned that he insulted the judge.
No, I didn't say.
No, he said that he insulted the judge in the open court, the presiding judge, and I now ask if anybody misconducts himself in the court, is it not contempt?
No, but
contempt in the face of the court.
But that judgment
so it cannot come in any way close to issue of terrorism. If the judge felt he was insulted,
whatever the judge may have said, obita.
The same way is good. The same way President Muhammadu Buhari now converted ordinary law of thought to a criminal offense. Nnamdi Kanu insulted Buhari. Yes, it's open. He called him all sorts of names. He has the reasons for calling him all sorts of names. We criticize such calling of names because he was our president. But we have a law that says, if I insult you, Dr. Abati, you take me to court. It's a civil offense. It can't be a crime that he insulted the president, and now the president now turned it to become terrorism. Now, another issue that's very important, another issue that still keeps hanging on is, if you look at all the counts, the 7 counts, a lot of them will be talking about his broadcasts. Almost about 5 of the charges talk about his broadcasts. And that is why his lawyer said, how has mere puffy, word of mouth, amount to terrorism? You know that when you are talking about criminal issues, you are talking about the actus reus and the mens rea, the reasons and the action. If
the mind to commit,
and then the act itself, committal of that act. Where is the committal of the act, and where is the mind to commit the act? What he did was he insulted the authorities because he possibly felt that he was not getting what he expected from the system. So these are all the issues that will come on appeal at the end of the day.
Don't let us reopen the case. All these elementary things about criminal law, let's put them aside.
Yes.
The matter has already been determined now at this stage. What is the way forward? What do you recommend?
No, but first,
as counsel?
No, it's very simple.
Were you part of?
No, I was not part of the legal team.
So, what do you recommend?
No, it's very simple. They will go on appeal.
Yeah.
And they have to go on appeal timeously because our law law says he has 90 days to appeal. But the legal team is up to the task, and they said they are not going to waste any time. But another thing that is important is that now that the written judgment is out, they get a certified copy of the judgment and they begin to prepare sift through it, bring out all the grounds of appeal, and then go ahead and file the appeal. And that's all. That is the only way forward. And the next way forward is to appeal to Igbo to take it easy, that this injustice cannot stand. So there's no need trying to get agitated. There's no need trying to resort to self-help. There's no need trying to injure ourselves or injure the people, all in the name of getting angry. Because the law, yes, is an ass, but the same law will be utilized to right the wrongs that have been done against Nnamdi Kanu. I say this advisedly and without any fear of equivocation, that the federal government of Nigeria has not handled Nnamdi Kanu's matter in a judicial.
So what do you advise the Nigerian government?
The Nigerian government, if I am to advise the government, this time around, the buck now stops on the table of the CNC. The CNC has now, when he pardoned some criminals, and Nigerians raised their voices, and people said, oh, why are you not pardoning Nnamdi Kanu? The handlers of the federal government, of the Mr. President said, the matter is still in court. Today, the court has discharged the matter. Now, the executive can now take over and apply the prerogative of mercy. It is completely at the discretion of Mr. President. And if I'm to advise him, I'll ask him to do so and calm frayed nerves so that we'll begin to limit the challenges of insecurity we have in Nigeria. It is mounting all around the country. Let us not add to the problems. It's like pouring fuel into a raging fire.
Don't forget to like this video and subscribe. As always, this is about perspectives, your domain for unfiltered news and raw political analysis. The constitutional lawyer was essentially questioning the attitude of presiding judge and whether the court acted according to the law or according to personal opinion just to ensure that Nnamdi Kanu ended up in jail. According to him, the issue was not whether Kanu defended himself or not. It was about the justice of the matter. And from his perspective, the judge was not fair to Nnamdi Kanu. And I'm reminding the audience that this man is speaking as a constitutional lawyer. Before we proceed, let's understand what a constitutional lawyer means. They say it is a legal expert who specializes in understanding, interpreting, and applying a country's constitution, the highest law of the land. What do they do? What are their functions? First, they interpret constitutional provisions. They explain what part of the constitution mean and how they should be applied. Secondly, They handle the constitutional cases. They represent people or groups in court on issues like human rights, government powers, elections, federalism, and constitutional violations. Third, they challenge the government actions. If a law or action by the government goes against the constitution, they can take the matter to court. Fourth, advice on constitutional matters. They guide lawmakers, organizations, or citizens on constitutional rights and limitations. This man also emphasized that in criminal adjudication, the person can only be convicted if there is a proof beyond every reasonable doubt. He pointed out that some people misleadingly use the phrase preponderance of evidence, but he clarified that preponderance of evidence is a civil standard, not a criminal one. In criminal trials, the correct standard is proof beyond every reasonable doubt, meaning the prosecution must prove its case so strongly that no reasonable person can doubt their accused's guilt, not an iota of doubts, but all reasonable doubt. The lawyer also stressed that justice must not only be done, but must also be seen, and in his view, aligned with the general public and international observers. Justice was neither seen nor done in Kanu's case. He also argued that the entire matter defies logic and raises serious questions. Nnamdi Kanu repeatedly asked the Federal High Court to show him the specific law under which he was being tried, because many people were confused. Why should a man be charged with an offense that is not known to law? This is a fundamental constitutional rule. When I tell my people, when I tell my friends that Nnamdi Kanu is being treated this way because first he's an Igbo and secondly the state resources is used against him. Now let's go into legal references. In Nigerian law, a person cannot be tried for an offense that is not codified. This comes from section 36 and 36(12) of the Constitution, which says that no one shall be convicted of any criminal offenses unless that offense is defined and its penalty is prescribed in a written law. And according to the constitutional lawyer, there is no such thing as a retrogressive action in criminal law. Let's understand what a retrogressive action is in criminal law. You could call it a retrospective or retroactive criminal charge, which is, as always, unconstitutional. You cannot punish someone today for something that was not an offense at the time the act was done. This principle is part of every democratic criminal justice system, and we are not in military regime. This was the answer the man gave. He also explained that Kanu was charged and convicted under old laws that had already been repealed. We keep on hearing Nnamdi Kanu shouting, "Repealed law, repealed law, repealed law." This is what it means. An angle many lawyers have not properly highlighted to the public. When he attempted to raise this critical issue on air, Ruben Abati cut him off, insisting that such matters should be left for the appeal court to decide. How? The lawyer disagreed, arguing that public must understand that a lot of unfair baggages was placed on Nnamdi Kanu. To make the matter worse, the jurisdictional question in Kanu's case had not even been addressed, yet substantive charges were already weak and watery. I believe that Kanu just needs a stronger lawyer, because some of his lawyers have overlooked, or should I say, underemphasized key legal defects in the case. Kanu himself had raised the issue of the repealed laws from the moment he opted to defend himself, yet his legal team did not aggressively pursue on it, just like how they ignored the issue of judicial question. Now remember, this explains why the Court of Appeal previously discharged and acquitted Nnamdi Kanu, only for the federal government to refuse to release him. The Supreme Court subsequently ordered the government to amend the charges, something the prosecution never complied with, right up to the day of the judgment. And they just maneuver everything. They bypassed everything and made sure Nnamdi Kanu was convicted. Now also, the lawyer mentioned the concept of fontus officio. What does this entail? A court becomes fontus officio once it has delivered final judgment, meaning the judge cannot revisit or alter the judgment. Secondly, the court no longer has jurisdiction over the matter. And lastly, any challenge must go to the higher court. According to him, Justice James Omotosho relied on Justice Bitanyaku's earlier judgment, raising concern over whether the court was simply trying to sustain a predetermined outcome. And this leads us to the fundamental question: are they going to manufacture a new law simply to keep Nnamdi Kanu in jail? When this Ruben Abati attempted to redirect the conversation, asking whether the case was, complicated by the conduct of the accused, that is Nnamdikanu. We talk about the way he was actually abusing the judge. The lawyer dismissed this as irrelevant before the charges. He argued that insulting a judge has no bearing on criminal justice, and the legal question remains, was justice done? This very legal erudite went further to say the judge's conduct amounts to a travesty of justice. What is the meaning of travesty of justice? A deeply unfair outcome, a distorted legal process, a judgment tainted by bias or improper motive, and an abuse or manipulation of judicial power. That is what you should understand as travesty of justice. And this was all orchestrated before Nnamdi Kanu. He also argued that the judge usurped executive powers by attempting to determine the specific place of confinement for Nnamdi Kanu, because determining prison placement for a convicted person is a function of the executive, not the judiciary. Secondly, the judge has no statutory authority to choose the exact facility. So such an action is what they call ultra-vires, that is beyond judge's power. This constitutional lawyer also accused the Buhari administration of converting law of thought into criminal offences, because insulting the president or anyone is a civil matter, not a criminal one. Even if Nnamdi Kanu insulted Buhari or judge, such speech should not, form the basis of a criminal conviction. He observed that 4 or 5 of the charges against Nnamdi Kanu were based on his broadcast, which raises the fundamental question: how does a mere broadcast amount to terrorism? Because this is actually what Nnamdi Kanu's lawyers were actually, asking. How did this amount to criminality? So in this case, people are asking, where's the intention to commit violence? The action itself, the weapons, the victims, the act of terror. Where are all these ingredients? Because these are ingredients of terrorism. Kanu was not seen with guns, explosive kidnappings, or any attack materials. So how did his broadcast alone become terrorism charges? According to him, the next step. He asked the lawyer, what is the next step? The lawyer answered, Nnamdi Kanu must appeal the judgment, and I believe they should do the needful in that very court of appeal. Secondly, the lawyer answered that Igbo people, the Igbo, must unite to challenge the injustice, because this conviction affects not only Nnamdi Kanu, but symbolically representing a conviction on the entire Igbo people. So the lawyer says Igbo should be appealed. For me, like I do say, Nnamdi Kanu carries the burden of every Igbo man, both living and dead. Therefore, many believe that his fate is directly tied to the fate of Igbo. As always, this is Abel Perspectives, your domain for unfiltered analysis and the story of facts that the mainstream media will never give to you. Don't forget to like this video, share, comment, and smash the subscribe button. Turn on the notification so you would always get notified each time we drop any undiluted breakdown. Thank you for watching.